Joanne Wicks.
Hi, how are you?
All right in the circumstances. How are you?
Yeah, not too bad. Not too bad, thank you. Good to see you.
And me, you. I need to talk to you.
Sure, go ahead.
You never guess the two questions that people are asking me.
Okay, what are they?
More than any other. The first question is, they say, you know, you couldn't defeat Joanne Wicks by saying that Brexit was an act of frustration. Do you think you could defeat her now by saying that COVID-19 is an act of frustration? And the second question they ask is, when I answer, are you sure you've run this answer past Joanne Wicks? So I'm doing that now.
Why not? Fire away.
So when people ask this question, do you think you could turn her over this time on COVID-19? I say, first of all, I turned her over last time, really. If you look very carefully at it, you'll see.
Cheeky rascal.
Yeah, you'll see on the law of frustration, paragraph 197, you'll see the victory is in there.
That is scraping the bottom of the barrel, I'm afraid, Jonathan.
The second thing I say is that Canary Wharf case was actually a quite old-fashioned application of the rule. It was about the purpose of the contract and the effect of the supervening event on performance, on the reason for the bargain, and that if you've got a position where the whole purpose of the transaction has been taken away by the restrictions that are currently in place, or even made illegal, then there's an argument.
Certainly, the illegality is an interesting aspect of the current situation, isn't it? I mean, there are a number of businesses that have literally been closed by law for an indefinite period. And that is really quite extraordinary in peacetime, certainly, isn't it?
Yeah. I mean, I think probably much depends on the relative length of the closures compared to the relative length of the interest.
Yeah.
And also the terms of the lease, about leases.
Yeah, that must be right. I mean, obviously, you've got things like the Panalpina case, like the National Carriers and Panalpina case, and that was where the access to the warehouse was shut for about 20 months, wasn't it? There was no access at all to the premises. 10-year lease, and I think it was started about 5 years in, and the House of Lords thought, well, the tenant's going to have enough benefit from this lease after the 20-month period of closure to prevent it being frustrated.
Right, but if it was, let's say it was a 10-year lease with only 18 months to run. Now, none of us know how long these restrictions are going to be in place. But with 18 months to run, could you say it's been frustrated? Because, well, first of all, you don't know when these restrictions are going to be lifted. You don't know how long of those 18 months it could still be enjoyed, if any of them.
But what about, what are you thinking about would be the permitted user of this lease?
Well, one of the cases that we argued in Canary Wharf was the Schlesinger case, which is interesting because it's about wartime, which is also something that has an indefinite period, rather like this pandemic. And Schlesinger, you'll remember, was an enemy alien because he was Austrian. And there was a rule that enemy aliens couldn't live in coastal towns, and he'd taken a lease in Westcliff-on-Sea.
Yeah.
And he only lost because, first of all, he was Austrian, obviously. Not a good thing to be at that time. But he also lost because the permitted user and the alienation covenants allowed him to assign to a friend.
Yeah. Yeah, he was freely able to assign. He personally couldn't live in Westcliff, but people generally could live in Westcliff. So he could have assigned, he could have sublet, he could even have let it to a friend, allowed a friend to occupy. But that's the interesting difference here, isn't it? I mean, if you've got if your lease is only capable of being used, say, as a restaurant.
Yeah, high-class restaurant.
A high-class restaurant, say, and that's the only permitted user, you can't assign to anybody who can use it for that permitted user, because every business, which is a restaurant, a high-quality restaurant, is being shut down. So that's definitely a difference from something like Schlesinger. And I think it's interesting as well to think about, what if you've got keep open covenant? Because the essence of the bargain is not just that the lessee won't do anything except use it for the permitted user, but actually has an obligation to keep it open and to be using it for example, for a restaurant business. So there's a strong element of kind of common purpose there, isn't there, which might be interesting in a frustration context.
So it is different. It is different from Canary Wharf. And I think the current situation is stronger. So if you've got only a short amount of time left on your lease, limited, if any, ability to do anything else with it at this time, apart from shut its doors and bolt its locks, then that seems to me to be fertile ground for a frustration argument, notwithstanding and built upon some aspects of Canary Wharf.
Yeah. I mean, obviously, we've got to remember the courts have been so consistently hostile to the idea of frustration of leases, haven't they? But I guess you could draw on some of the American cases in relation to prohibition, where leases for, a saloon or bar, when the sale of alcohol was prohibited, some of those were successfully argued to be frustrated.
Yeah.
That's probably where I'd go if I was looking at this on behalf of a client.
Yeah, and the other place I would go is to look at the cases about length of time, where the frustration failed because the length of time that the lease wasn't able to be used was a short amount of time relative to the overall term, and say this is relatively a longer period, not least because the end point is uncertain. We don't know whether these restrictions are going to be lifted and then reimposed, and lifted again and then reimposed. We've got no idea what's going to happen. We've got no idea what the end of this process is going to be.
Businesses have to take their decisions now, don't they, on the basis of what they perceive might happen over the coming weeks, months, and possibly years. And that's really difficult to forecast.
Yeah, absolutely. But there we are.
Anyway, good to speak to you, Jonathan.
Me, you. I can now say I've run my argument past Joanne Wicks, and she broadly agrees.
As I always do.
Bye, Joanne.
Speak soon. Bye.
Bye.